welcome to Crime and Court. My name is Heather, and this is a transcript reading of the May 18th hearing for the motion for contempt that Prosecutor Nicholas McLeland filed with the court. And so basically he wants the judge to find them in contempt for a bunch of things that really don't add up to contempt in legally speaking, but so it's a bogus motion to begin with, but Judge Gull says, okay, let's have this hearing, and Baldwin and Rosie, Alan's attorneys, say, you know what, can we delay this? Can you give us some more time to prepare for this contemptuous conduct hearing? And she denied it. And so yeah, they didn't have the time that they had wanted, and all of the discovery, I think, that they had asked for as well, and we're going to get into it. So there were two hearings that day. One was the motion to dismiss the charges altogether from Richard Allen, and we already read that on my channel. Thankfully, luckily, because there were no cameras, we have the written transcript. Unfortunately, it's not as good as audio, but it is pretty good. I mean, it's the best we have, and that's how we've been doing it for ages, so whatever. I hate that. We've been doing it this way this whole time. Well, we could improve it. Anyways, so the motion to dismiss, we already read through. That came from the defense diaries and a couple other content creators. I'm not sure who exactly, but I watched it on the defense diaries, and he said him and somebody else collaborated, pooled their money together to get the transcript. So now, thankfully, another content creator has stepped forward, put money forth to purchase the transcript for the contempt hearing, which we never got to hear yet. So this just recently came out. Criminality, I think, is how you say it. I am a subscriber now, but I had not really heard of their show, or well, I think I've heard of them, but I hadn't watched their show until I just saw this pop up in my feed that they were doing a reading of the contemptuous hearing, and they have provided so generously a Google document to share with the world, because the message here is clear. They want silence, and they don't want the world to see what's going on in Delphi, but we're not going to accept that answer, and we are going to try to keep our government accountable. And it seems like everywhere I'm looking right now, our government is not being held accountable. Sorry, I'm trying to center this. There you go. It drives me nuts if it's not centered. All right. So the Honorable Francis Siegel, and our reporter here is Jody Williams. Is that right? Yeah. All right, so Jody Williams, thank you. All right, so this is the proceedings. The court says State of Indiana versus Richard Allen. We are here on multiple pending motions. I think the first motion I set was the state's motion to leave to amend its charging information. Attorney Nicholas McLeland steps in and says, yes, Your Honor. Your Honor, before we get started, I'd like to introduce to the court Deputy Prosecutor Stacy Diener. We brought her on board to help assist with the case and try the case. I was notified today that a tradition, at least in Allen County, to enter the appearance for the deputy prosecutor, so I'll follow this up with a written appearance today, Judge, after the hearing. Okay, good morning, Ms. Diener. Good morning. Try to do voices. The Criminality channel, they did a really good job, because they hid their picture and they had it like a picture of Hennessy was speaking, or a picture of Gull was speaking. So they had multiple people on the channel, so they could do different voices. So it was kind of fun to watch. But anyways, I'm sorry that I can't do voices. All right, it would be distracting anyways. Mr. McLeland says, Judge, the state has filed an amended count, or an amendment to add counts, and would like to add counts 3 and 4. So this is referring to adding more counts to Richard Allen's charges. He did not have charges for the homicide. He only had it for kidnapping. So now they're adding the homicide charges to his charges. The state's going to make an oral motion to dismiss counts 5 and 6. I think there's an argument to be made that those are allowed to be filed outside the statute of limitations. But given that we are past the 5-year mark on those, Judge, I think it's appropriate to dismiss those two. And so the state's not going to go forward on counts 5 and 6. So the amendment is just here to add counts 3 and 4, Judge. We believe that's allowed. We believe that's appropriate at this time. Those counts better match the discovery that we've submitted to the defense and better match the probable cause that's been filed with the court. We did that. We filed those counts in plenty of time for the defense to prepare for trial. We believe it's allowed under the statute and ask the court to grant the same. Allow the court leave to file those 2 additional counts, Judge. Mr. Rosie, Mr. Baldwin, Judge, we have no objection. Then I will show without objection counts 3 and 4 are added, and I'll grant the state's oral motion to dismiss count 5 and 6. Do you waive initial hearing on the added counts, gentlemen? Yes, ma'am. Thank you. That takes care of that. The next motion then, that was set by the court, and I don't know if we want to take this up or if it's what everybody's position is. The state filed a motion for all future pleadings and filings to be sealed for the court's review before being released to the public. Mr. McLeland. Judge, that motion was filed, I guess, prior to the last hearing that we had back in October. I can't remember the day, October 17th, I think. At this point, Judge, the state's going to withdraw that motion. I had forgotten that it was filed and still pending, Judge. I apologize. Okay, that's fine. Then I just want to make sure that we're clean on the record. So I'll show that as being withdrawn. I know that the defense is in contempt proceedings, filed, verified emergency motion. Did you get those orders to them? Court reporter says yes. The court continues. Okay, so you've got the orders where I've denied the verified emergency motion for continuance, the supplemental motion for continuance, and I think that was it. So that's been resolved. I'm not sure, Mr. Hennessy, on March 12th, you filed a motion to stay all ancillary proceedings and get this case to trial. I'm not sure, and I know the state filed its objection to that. Did you wish to be heard further on that? No, Judge, it makes perfect sense in my mind. Fucking judge. Ugh. She bothers me so much. All right. The court. It just what? I'm sorry? You said it makes perfect sense? Yes. Anything further on that, Mr. McLeland? No, Judge. Just note our objection. We've continued this hearing once before to give the parties ample time to prepare. The state's ready to proceed forward, Judge, today, and so we prefer to proceed forward today. I can't remember, but I don't think she gave them a whole lot much more time to prepare. It was still just a couple weeks, I think, maybe. I don't know. Can't remember. I feel like that was so long ago in this case, and it really was in this case. It's just like the case that never quits. All right, so the court says, and we will proceed forward. So I'll note the motion, deny it without hearing. Big surprise. I understand that you've indicated, sir, in paragraph 4 that this hearing will last at least 1 day and probably 2. I have scheduled this for 1 day, so you'll need to conduct yourselves appropriately to make sure it gets done. What a bitch. Defense has also filed a motion for specific findings of fact and conclusions thereon. That's obviously going to be granted, and I will make findings. Defense also filed an objection of change of venue. I've noted your objection. Mr. Hennessy, this is to the change of venue? Yes, sir. Okay. Would the court be inclined to identify any exceptional circumstances that's referenced in the rule? No. Okay. God, she's a bitch. How many times am I going to say she's a bitch? Let's just have a counter. I don't know. I should have a counter. Let's not. It's too much. All right. So, Mr. Hennessy, okay. The court, I've noted your objection. It wasn't filed until March 12th. This matter has been pending since, I think, January, when the state filed its verified information for contemptuous conduct, January 29th. But there have been so many freaking motions in between that how are they even supposed to respond to everything appropriately when they're being bombarded by BS from the state? Sorry. I got a little heated there. All right, so I set the first hearing in February. That was continued to today on defense motion. That was continued without objection, so I don't find it's timely at this point, but based on your concerns and your objection, all future hearings, if there are any outside of this trial, will be conducted in Carroll County. Just reminding counsel that you all have agreed to conduct jury selection here in Allen County with an Allen County jury. And then the final motion that I have pending is a verified petition for recusal of the prosecutor for contempt proceedings. Mr. Hennessy says, yes, thank you. Oh, wait, I think he's a necessary witness, and I've explained to him that, and I've explained why I think he's a necessary witness. In particular, we're going to have evidence, and there's a Gary Baudette that goes by Fig Solves, and a few other handles, and that he and Mr. McLeland were exchanging communications and information. We'd like to know what that was. There were other leaks that we've investigated and have become aware of and were not investigated, and those leaks were more substantial than the allegations against attorneys Rosie and Baldwin. For instance, there were 2 leaks of probable cause affidavits. The sealed probable cause affidavit that was submitted in support of the charging information, which had details of the investigation. Then there was a leak of the affidavit for probable cause to search Mr. Logan's property, which neither of those could have come from the defense, and they were more substantive than what's alleged against the defense attorneys. So there have been other instances, and he just provided 2, where, I'm sorry, I need to move this. I'm going to put the heating pad on my hip because it hurts. Excuse me. So there were multiple leaks, and they were more egregious and worse than what happened, more widespread too, than what happened in the, stop making noise, than what happened in the, whatchamacallit, in the defense's case. Sorry, okay. Needed that little bit of heat. I might turn it up too. Sorry, I'm being noisy and I'm all distracted now. Let me take a sip of water. So multiple leaks of other things, including affidavits and things of that nature that were worse and had more details and things that shouldn't have been leaked outside to the public. And he's saying there's no way we're responsible because we didn't even have that information. So neither of those could have come from the defense, and they were more substantive than what's alleged against the attorneys. So worse, more graphic, I guess, and more detailed. So there's others of those that Mr. McLeland knew about and could have directed investigations, and we'd like to know why not, because I intend to show that this is a targeted prosecution for criminal contempt. So I think he should recuse himself because he was also intimately involved in the investigation. For instance, when Sergeant Holman was interviewing Mr. Fortson, and he told Mr. Fortson he was going to call the judge and ended up calling Mr. McLeland and then reported back to Mr. Fortson some additional threats about jail and contempt and obstruction of justice. So that's a conversation that was during the investigation, connected to the investigation. So I believe that he is a legitimate witness on that basis. Damn. So this Mr. Fortson, he's the one that I believe committed a self-deletion, and looking at all this, it might have been like there was some law enforcement pressure on him, some police pressure, asking him to, I don't know, give up his source. If he didn't cooperate with the investigation, I don't know. Why was he telling the judge that he was going to, or why was he telling Fortson that he was going to call the judge? Just because. Just because he was threatening him. I don't know why. So that's a conversation that was during the investigation, continued on to the investigation. So I believe that it's relevant. And there's other involvement in the investigation and other knowledge of the leaks. And then we believe that the prosecution is going to allege that Mr. Westerman, he's still undergoing criminal proceedings for his involvement in taking the pictures from Andrew Baldwin's office. So, or taking pictures of the pictures, I guess, is what he did. And then we believe that the prosecution is going to allege that Mr. Westerman took 9 photographs without permission in the conference room of Mr. Baldwin's law office. But we don't believe that all 9 of those were taken by Mr. Westerman, and we will have evidence as to why they could not have been. So that's why I think Mr. McLeland should recuse himself from contempt. As you can see, there are too many lawyers for the prosecution here today. Two other lawyers. Sorry, I read too many. Sorry, maybe it is too many. One with more experience than Mr. McLeland. Damn, throwing a little shade at Mr. McLeland. And then they could easily handle the proceedings. The court says, Mr. McLeland, Judge, a couple, I guess, different objections to make Mr. Hennessy's motion. I'll try to take them in order that he recited them to the court. In regards to the communication with a Gary Baudette and then other leaks that the defense believe occurred in this case, I'm not sure how that evidence is relevant and what we're here to do today, Judge. In the state's mind, we're here for a very narrow focus, and that is to present evidence that supports and the information in the state's filings of contemptuous information. We're not sure how communication between I and another person and then other leaks that the defense believe occurred have to do with anything with the allegations outlined in our information against Mr. Rosie, Mr. Baldwin. So don't look at the things that I've done wrong, Judge. Only look at them, because my sins against this case, the things that I'm doing egregiously, those don't matter, but only the defense. So let's just look at them. Even though I'm doing worse on my side over here, but shh, look over there. And so I don't think that information is relevant or even pertinent to the court to hear in support of or in denial of our information. Again, Rule 401 says it is to be relevant, there has to be a tendency to make a fact more or less probable than it would be without the evidence. That's not the case here. The defense seems to want to say that hey, we leaked information, but it's okay because the state leaked information. That is, well, yeah. I mean, no, they're not saying it's okay. They're saying they didn't even do anything wrong on their end. I mean, you've got the wrong guy in here right now because your problem is with Mitch Westerman, who took the photos, not my guys Baldwin and Rosie, because they didn't do anything wrong. I don't think. Anyways. All right, so the defense thinks, hey, we leaked information, but it's okay because the state leaked information that is, in their mind, more important. And it's not more important, it's more egregious what you did, not more important. And I just don't see how that's relevant. So that's the first argument in regards to Baudette and the leaks. If the court does find that it's relevant, again, the rules seem pretty clear that only in extraordinary circumstances can an attorney be called as a witness. If the court takes a look at Chapman versus State and Matheny versus State, Those are both good cases, and they say that the general rule is that counsel is not subject to being called as a witness unless it is required by a compelling and legitimate need. So, what do you think? Gull's going to let him be called as a witness? Probably not. All right, so where the evidence is easily available from other sources and absent extraordinary circumstances, an attorney who participates in a case should not be called as a witness. But don't make yourself a witness also. You can be called. It doesn't exclude you from your misconduct. And again, that's under Matheny. Judge, here, if that evidence is relevant and the court does allow it in, they're able to get that through other means. They could call Gary Baudet. They could call other people that they believe are involved in the leaks. It isn't necessary for me to testify on those matters, Judge. In terms of the Westerman photos and how many photos were took, that's grammatically correct, were taken by Mr. Westerman. Again, they have Mitch Westerman here to testify to how many photos he took, and so that information is easily accessible through other witnesses. The state believes that it is an attempt by the defense to derail the hearing today. Knowing that I'm the one that prepared for the hearing on the contemptuous information, Judge, and the other two prosecutors seated at the table haven't prepared for that, and so I think it's an effort by them to derail the hearing and would ask that the court deny the motion. Anything further? Thank you, Judge. This is clearly an information for indirect criminal contempt. The law is that respect gives the accused, the defense attorneys, all the rights of any citizen accused of a crime, including the right to present evidence, including representation. With regard to the relevancy, Judge, since it is an indirect criminal contempt proceeding, there are two issues. One, is there contempt? Two, if the court finds contempt, what is an appropriate punishment? The fact that Mr. McLeland, misspoke. They didn't release anything, not once. They didn't post anything publicly. It requires public dissemination. And so, when the accusation is false, and then he accuses me of having ulterior motives, which is also false and not appreciated. But on those two issues, whether they're in contempt or not, other leaks are relevant and probative on that issue because it requires willful conduct. Now, all these other leaks were purposeful. The people that posted it and leaked it, and keep in mind, it was more substantial information than what they're accusing them of, the attorneys of, that was willful, so that's a perspective. With regard to punishment, the fact that two probative cause affidavits leaked details of the investigation. They alleged crime scene photos that were stolen by Mr. Westerman those crime scene photos were going to be in evidence eventually. There's just no way around it. The probable cause affidavit, no. And they had more details. They had specific details. They posted information about the bullet and the gun found in Mr. Allen's house. That was not from the defense, and that was far more damaging in terms of leaks, so that's why it's relevant. Damn. Good. With regard to having Mr. Westerman here, I also wanted to ask Mr. McLeland what he did to get Mr. Westerman here, because he listed him as a witness, scheduled a deposition, he didn't show up, and with Gary Baudet, we can't get him here, and there's another reason when I'm going to renew my motion for a continuance, but since he says no, since I can't get other people to say what his communications were, he shouldn't have to testify. He's kind of trying to shift the burden. So if the court's gonna buy that, then I need time to do what he wants me to do, and we'll have to ask the court for some money to do that. So he's here. It's not my fault that nobody else got prepared for the hearing because he's known for weeks. I told him early on when I got on the contempt proceedings that I intended to do that, and I've never changed that position. With regard to, and the other thing, the clean hands doctrine, I think gives us relevancy with regard to the testifying. And then get Westerman here. What else did he say? Oh, also another thing that we would want him to testify to is after the court issued the gag order, there was an in-chambers off-record conference with the attorneys and he participated in it. Basically, that was modified informally to allow the defense to share some information with regard to strategizing and preparing for trial. And he was present for that. I believe we'll have testimony that he didn't object, and so that's another reason he should testify. So for all those reasons, it is relevant. The other leaks are relevant. Surely there's more than what I've laid out for the court here, which will be there's evidence as we go through the hearing. The court says, well, while I'm not conceding that anything from outside sources is relevant, if it may be relevant, then I suppose, but I see no compelling reason to have Mr. McLeland called as a witness to testify and will deny your verified petition. Mr. McLeland, are you ready to proceed on your information for contempt? And get ready for a lot of these calls. She's just going to deny the defense pretty much everything. So I'm just preparing you. All right, Hennessy says, I'm sorry. I'm speaking with Mr. McLeland. Oh, I didn't know. Yes, Your Honor. Do you wish to make a preliminary statement or just get right into the, Your Honor, testimony? If I may, I have some preliminary matters I would like to discuss, Hennessy says. All right, so the court says, please don't interrupt me. I'm not done speaking with Mr. McLeland. Did you wish to make any preliminary statement or just get right into evidence? She's a bitch. Mr. McLeland says, Judge, I prefer just to get right into the evidence. I think my information outlines what we intend to present here today, Judge. Mr. Hennessy, I have some additional preliminary matters, if I may. Sure. Thank you. First, I would like to supplement Mr. Osbrook's filings, which I'd like to have marked as Exhibit A, if I may approach the court reporter. You may. May I? I'm sorry. I said you may. Thank you. Mr. Hennessy, there was some audio issues going on that day because defense diaries, Bob Mata, I believe he said he was in attendance, and he said that it was kind of funny because nobody could hear anybody. So there was a lot of what? Huh? That's me, 24 hours a day. I cannot hear anything. All right, so you may. All right, so Mr. McLeland says, Mr. Hennessy? Yes, sir. Oh, thank you. So, Judge, Defendant's Exhibit A is a publication, a bench note from the Supreme Court that was updated on January 1st, 2024 that lays out the procedure for the various types of contempt proceedings, if I may approach. Defendant's Exhibit A offered. The court says, if there, excuse me, is there any objection to Defendant's A? McLeland says, Judge, I don't have any objection. The court says, show Defendant's A as admitted without objection. Mr. Hennessy says, do I give it to her? The court reporter, yes, please. Hennessy says, thank you. And then I would like to renew my continuance. As the court knows, in my verified supplement in my verified original motion, the discovery that I was receiving from the state was delayed. And I'm not alleging that. I'm not alleging that anything improper in that regard. It just affects the effects of what I've been able to do. For instance, the original Indiana State Police report regarding their leak investigation did not have the attachments because someone clicked on the wrong button. We discovered that, both Mr. McLeland and I, on March 1st, and then I didn't get them until, because of some kind of e-discovery glitch, I didn't get them until the next Tuesday, and I went from 33 pages to 272 pages. That is bullshit. Like, I would be furious as a lawyer. Like, stop playing games with me. I know you're playing games. Just hand it over. Stop waiting till the very last minute so I'm bombarded in discovery that I can't do anything with at the last minute. Gosh, I hate games like this from prosecutors, and I'm seeing it everywhere. And so I was able to go through that late last week, and there's a lot in there that I would want to follow up on investigation on, and I need more time to do it. Mr. Mullins recorded Mr. Woodhouse's YouTube, and with regard to Mr. Woodhouse, from the framing of the pleadings on the contempt proceedings, it would seem to be the accidentally misdirected email, which only had an attachment of an outline organizing discovery. So there was nothing really, nothing bad in it. It was just a line item. Like, each line has a different item on it saying, like, clothing, hairpin, like whatever, hair tie, whatever. Every little bit and piece of evidence or discovery. And, emails from Nick McLeland to that Fig Solves guy. So that would be on there. Every little piece of discovery that they have that they're going to use, it's a line item. That's the only thing that he sent to this guy. And the state is appalled by that. Like, what? Who cares? It was a misdirected email, like they said. And it went to B.R. Brandon Woodhouse instead of B.R. Bradley Rosie, the other lawyer in this case. So it's an honest mistake, and why it's even being brought up is just completely ridiculous in my opinion. All right, so sorry. It would seem the accidentally misdirected email, which only had an attachment of an outline discovery. And then I've not had time to watch the entire YouTube presentation of Mr. Woodhouse, but it appears that he also had photographs which could not have come from the defense, and there was no connection between him, Mr. Westerman, Mr. Fortson, Mr. Cohen, or anybody else that claims to have received them. So there was only a select few of people who actually received these photos. Brandon Woodhouse is a YouTuber that put them on his stream. I'm sure it's been taken down by now. However, the police probably have it. But that is pretty much the extent of the leak. And that's why it's being called a drip, really, more than anything. Because it really didn't do a whole lot. It hasn't gone anywhere. Like, you need to intentionally, willfully do something to disseminate that information, and they did not do that. In my opinion, they did not. They shouldn't even be here, but that's another story. All right, so let's keep going. We've got a lot more to do. All right, so I should stop talking so much. All right, I got the recorded. Wait, where was I? So he hasn't watched the full thing of Brandon Woodhouse, but it appears that he also had photographs which could not have come from the defense, and there was no connection between him or the others. I got the recorded interviews taken by Sergeant Holman late. I've listened to them, I've taken notes, but I didn't have time to get them transcribed, which would simply make the ability to use them to cross-examine any witness more difficult, but not impossible. Mr. Snay contacted me within the last 3 or 4 days and shared information that he had about other leaks, which I would need to investigate and try to track down. We received additional screenshots from unknown people, and I need time to investigate that. Also, just in terms of adequate organization and making exhibits for presentation in an adversarial hearing, I need more time. So according to, I cited the case in my motions and I've identified for the court and I need more time to do. So I renew the request for they're entitled to adequate representation as indicated. It's indirect contempt. All the rights and privileges of any citizen accused of a crime are present, and that includes the time necessary for adequate representation. Thank you. Mr. McLeland, Judge, I'll try and take these in order again. I tried to jot them down. In terms of the ISP report, it was made available that Friday. Mr. Hennessy didn't want to drive to Delphi to get it, and so we attempted to deliver it through e-discovery. We attempted 3 times, and then he got it on Tuesday. Well, what's your issue that you couldn't get it to him? Like, what? E-discovery should be like a no-brainer. You should be doing these like daily for cases. We attempted 3 times, and then we got it on Tuesday. I can't explain why he got it on Tuesday and not that Friday, but that is true that we tried it. So, I don't think they did, but they say they did. Mr. McLeland, and I don't believe you. All right, so we did on e-discovery only because he didn't want to drive up to Delphi to get it in the physical form, and so we were attempting to get it to him to accommodate his desires not to drive to Delphi. Mullin's recording of the YouTube channel, my information is that he's got that. He's had the time to examine that. The recordings from Holman, they're not transcribed. I don't know that matters, Judge. We can still question Holman about those today. If he's got notes on those, then he should be able to go forward on those. The other leaks, again, Judge, I'm not sure how those are relevant to today's hearing. We're talking about the information the state filed with the court and not about other leaks. And so I'm not sure that's relevant. And the screenshots, I'm not sure which ones he's talking about. He did provide me with some screenshots. If they're the same ones he provided me with, again, I'm not sure how they're relevant, Judge, to today's hearing. So the state would ask the court to deny the motion. Anything else? Mr. Hennessy continues his argument. Well, I appreciate Mr. McLeland believing that I should be ready, but I'm not, and that's the key. And the key is that if I provide the court with specific reasons, and I've done that, and it's just a matter of fairness and justice. Thank you. The court says, all right, your supplemental motion for continuance is also denied. Anything else? Ow. Mr. Hennessy says, and then, thank you, Judge. I would like to, I'll take that up at another time. I also had filed there, Your Honor, I need to interpose an objection to the lack of a special judge. It's clear that the information for contemptuous conduct was filed pursuant to 344735D, which provides that indirect contempt requires a special judge for any part of the allegations that are not alleged to be a violation of direct order of the court. So they've alleged the press release, which was a day before the order, so it cannot be directly connected to an order of the court. They allege a failure as if there is some obligation to notify the prosecution and the court that there was a misdirected email that was accidental and that Mr. Baldwin followed up on with the wrong recipient within the hour, asked him to delete it, so he had every reason to believe it was clear. But there's no direct order of the court that applies to accidentally misdirect emails. The conversations that they got out of Westerman's iCloud account, that's not a direct order. The failure to secure evidence and discovery materials, there was no order from the court that they secure any such materials. Not being completely honest with a court, that involves, 1, it's false, but 2, that involves evidence away and apart from. So for all what 344737C says is that for all items not related to a court order, including any claim of contempt based on acts cumulatively taken, a special judge has to be appointed under IC 34473C or 37C, blah, 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 all those numbers and C. That's also in the bench note that was issued by the Indiana Supreme Court. So I request a ruling on my objection for the lack of special judge for the contempt proceedings. Mr. McLeland, Judge, I think if the court takes a look at Section B, that Indiana code, it states this section does not apply to an indirect contempt growing out of willfully resisting, hindering, delaying, or disobeying any lawful process or order of the court. That is not at all what any of those. They did not do any of those things. And so I think this allows the court to proceed over this information with the state that the state has filed. The court says, well, and I would find that the February 17th, 2023 order that was issued at the state's request for a protective order governing discovery is an actual order. Mr. Hennessy, your objection is noted. Mr. Hennessy says, and then I'd like to, you've not ruled on it yet, but I did file for a judicial recusal, and I would like to have marked and admitted into evidence your email from October 8th, 2000. Damn, like, how do you go up against a judge and say, I want you recused? And here's some evidence from your emails and your as Exhibit B, and then your email of May 2nd, 2023 as Exhibit C, if I can approach the court reporter. The court says, you may. When was that filed? Hennessy says, I'm sorry. When was that filed? Oh, the recusal petition? Yes, I'll have to look. Judge, it was filed the same time all the other motions were filed. The court says March 12th, the motion to recuse. Okay, I found it. Should have been all filed on the same date. Thank you. Is there an objection to whatever is? No, Judge. Sorry, I didn't know the court was waiting on me. I apologize, says Mr. McLeland. The court says, no, that's okay. I don't know what your exhibits are. Hennessy says, may I approach? And then the court says, have they been marked? Yes. Okay, what are they? It's your email from October 8th, 2023, and the court says, and what is that exhibit number, sir? B is the October 8th, 2023, and C is the May 2nd, 2023. The court says, all right, I'll show without objection B and C are omitted. I feel like dirty doing her voice. I have to do it all mean and like nasally. Sorry, that's my Judge Gull voice. Nobody else gets a voice but Judge Gull. Defendants' exhibits B and C are admitted. Mr. Hennessy says, and then with regard to the judicial recusal, I would like to call Sergeant Holman for some brief testimony. If you'd like me to sum it up, I would. She says, why don't you just sum it up? I'm sorry, says Hennessy, sum it up. I can just see all these people like, huh? That would be me. Okay. When he interviewed people, this is Hennessy speaking, sorry. When he interviewed people, he invoked the power of the court, and he would tell them that the judge is very adamant that they delete the photos or give them to him. He indicated that you would issue contempt of court, and with Mr. Fortson, he said he could call you, reach you immediately, and see if you wanted to issue that order of contempt. So what he put in the minds of other citizens was the court was deeply involved in the investigation, ready at a moment's notice to send them to jail. That's a great point. That's a great point. And I would like to have his testimony on the record in support of the judicial recusal, so it's on the record. The court says, is this an offer to prove? No. I want to call him to testify. Any objection, Mr. McLeland? Judge, again, let me I guess, address Exhibits B and C. I don't think that those exhibits show any bias on the court's part. Kiss ass. I'm familiar with those emails and, again, don't show any prejudging by the judge or any basis towards anyone involved in this hearing. In regards to the testimony of Sergeant Holman, I guess I'm not sure how his statements show that this court is not appropriate to preside over these matters. And so again, I don't think it's relevant in terms of the motion for recusal, Judge, and so the state would object to that. Well, in your motion, sir, in paragraph 10, you indicate that the court conducted its own investigation. I did no such thing. I directed counsel to cooperate. I directed counsel to get to the bottom of what was going on. Your request for recusal is denied. She really should have recused herself. She should have recused herself from Richard Allen a long time ago. Or the Supreme Court of Indiana should have just taken her off this case. I don't know. There's so much bias in the way she's ruling. And it's apparent and obvious. She kisses Nick's ass, and every single filing that the defense has, she denies it without hearing. Crazy. I've never seen this. All right, so where were we? The court says, did you have any other preliminary matters before we get to Mr. Hennessy says, I'm looking because you've made some rulings just here today. I need to take a look at my list. No, ma'am. Mr. Hennessy says, I would do a brief opening statement if the court would allow. The court says, go ahead. So Mr. Hennessy says, thank you. As I pointed out, Judge, because they are the plaintiffs, right? No, they're the defense. So I don't know why they get to go first with an opening statement. I don't know. Anyways, they're defending. They are the defendants. So I don't know why they get to go first, but I guess the hearing is different than a trial. All right, so Mr. Hennessy says, thank you. As I pointed out, Judge, there are two issues. One, whether there is contempt, and two, what an appropriate punishment would be if the court does find contempt. With regard to the contempt, the information, it is not properly filed. The information should have been filed in a separate action. It fails to give adequate notice of what exactly they are alleging was contemptuous conduct. What I can glean from the filing is that the press release of December 1st, and there was no order prohibiting that until December 2nd, and then they say that misdirected email. That was not willful. There was no duty or obligation to report it, and when it was discovered that Mr. Woodhouse had been dishonest about deleting it, both Mr. Baldwin and Mr. Rosie were open, honest, and completely cooperative. And then, as I indicated earlier, the perspective, the alleged leak, and this leak, and then so I don't know what else they're alleging. Oh, Mr. Westerman, but they've charged him with conversion, whatever that is. So if somebody breaks, and they're apparently saying that that violated one of the court's orders, but it has to be willful. If somebody breaks into my office and steals embarrassing photographs and then puts them on the internet, that's not my fault. I didn't publicly disseminate any embarrassing photographs, and that's exactly what the allegation regarding Mr. Westerman is. They admit that they were taken without authorization. Both Mr. Baldwin and Mr. Rosie cooperated in the investigation. So on the facts and the law, after all, the evidence, should not be any finding of contempt. Thank you. The court says, do you wish to make any statement, Mr. McLeland? I'm sorry? Mr. McLeland says, Judge, again, I think the information and testimony we have today will speak for itself. I think I've outlined in my information that from the evidence the state's gathered, we believe It's more than just Westerman breaking into the office of Mr. Baldwin. From the evidence we've gathered, it looks like it was a continuous and ongoing leak until the leaked crime scene photos and so on. All this is outlined in the information, Judge. I don't think it's necessary to regurgitate it all to the court here today. And so, the state's ready to go forward with evidence, Judge, and jump right into it. The court says, "You may call your first witness." Mr. McLeland says, "Judge, before I call my first witness, I would ask the court to take judicial notice under Rule 201 of the gag order that was filed by the state on November 22nd, 2022 in this case, and then the court's order granting the gag order." So, a gag order that was filed by the, So the state filed a gag order on November 2nd. I believe it was denied. And then the court did grant a gag order by December 1st because the defense spoke out in Richard Allen's defense in a very appropriate manner. I can't remember what it was, but I mean, it was just a statement like any other defense lawyer says, like, we believe our client didn't do it. We believe the facts will prove the case, blah, 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 blah. But they didn't like that. They didn't like that at all. So they put in a gag order the next day, but it didn't come in until the 2nd, not the 1st. So Nick McLeland is lying right here. He says the gag order, granting that gag order December 1st of 2022. That is incorrect. It was granted on the 2nd. And then I'd also ask the court to take judicial notice that what I'm going to have marked as State's Exhibit 1, which is the press release released from the defense on December 1st. So let me find that press release, if I can. Press release. So it was December 1st. Of 2023. No, 2. Sorry, 2. Let me see if I can find it. Defense press release, December 1st. Here we go. Awesome. All right, so, it's long. It's a long one. I don't want to read it, the whole thing. Basically, okay, so I'll just read you like the first little bit of it, and then maybe I'll read the full thing on another stream because it's long. It's like 3 pages long with no double spacing, so I don't want to sit there and read this. All right, so press release. As Rick Allen's attorneys, we have received multiple requests from local and national media for interviews and comment since the unsealing of the probable cause affidavit. So first, they unsealed the probable cause affidavit, and that is why they responded with a press release, and that's the only reason why they responded with a press release. So if the state would have not unsealed the gag or the probable cause affidavit, the PCA, then they wouldn't have done this press release at all. Anyways, so because of that, the media was reaching out to them. And it would be virtually impossible to comply with these requests and continue to focus on the merits of Rick's defense. Therefore, we offer up these thoughts. And there's a lot, but I'll just give you a little bit. So we do not want to try this case in the media, and we intend to adhere to the Indiana rules of professional conduct that provide guidance on pre-trial publicity. However, the police and prosecutor's office have conducted many press conferences over the 5 years of this investigation, and following our client's arrest, on the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference. So this is the key issue, guys. The goal is trying to silence the truth, and that's a problem. Why are we not looking harder at this? Okay. The police and the prosecutor's office have conducted many press releases. Rick's ability to assert his innocence has been reduced to nothing. Accordingly, we feel it appropriate, necessary, and within our bounds of our rules of professional conduct to make a few comments concerning the probable cause affidavit and Rick's innocence. So they go on to say multiple things. So I'm going to save the rest of it for another stream because I sent it to myself here. So we'll do in another stream. I'll read that and the probable cause affidavit because I don't think I've ever read the probable cause affidavit in this case. Maybe I have, a long time ago, potentially. DELPHI, sorry. Okay, so let's get back to it. One sip first. Gotta hydrate. All right. So State's Exhibit 1 was offered. The court says, all right, I will take judicial notice of the motion that filed by the state of Indiana for an order prohibiting parties, councils, law enforcement, etc. The gag order that was filed November 22nd of 2022. We'll also take judicial notice of the gag order for this court entered on December 1st. Lies. It's the second, granting the state's motion for a gag order. And State's Exhibit 1 is the press release that was issued by the defense counsel. Any objection? Mr. Hennessy says, well, first, I object to judicial notice, and I'm looking for it. Both McLeland and the court indicated that was issued December 1st, 2022. Correct. And the chronological case summary says December 2nd, and I'm trying to find the gag order because I've reviewed it a number of times, and I believe it was filed marked December 2nd, 2022, but I would like to clarify that. So I would object on relevancy on State's Exhibit 1. What was it? The press release. I would object on relevancy because of the prospective dates. Court says, all right, I show that the court granted the defendants or the state's motion on December 2nd. I will take judicial notice that the order, December 2nd, 2022, on December 1st, I set that for hearing. Wow. So it's December 2nd, correct? Correct. They were gonna, wow. Just wow. They were both gonna just go with December 1st, McLeland and Gull, knowing full well it was the 2nd. Well then, therefore, I do object on relevancy because the press release was dated December 1st, 2022, so that order cannot be relevant to something that was done the day before. So you're objecting to State's Exhibit 1. That's my objection to State's 1, and it's also my objection to the court taking judicial notice. 1, under 201, it says you can take judicial notice if provided accurate information, and you were not provided accurate information because he said it was December 1st, 2022, and the court accepted that assessment until reviewed at my request, so it does not fit 201. Mr. McLeland, Judge, under 201, the court can take judicial notice of a fact that is not subject to reasonable dispute because it's generally known within the trial court's territorial jurisdiction, and it can be accurately and readily be determined from sources whose accuracy cannot reasonably be questioned. What? What does that even mean? In terms of the two orders, those are part of the CCS, Judge. Mr. Hennessy is right. I misspoke. It looks like it was ordered on December 2nd, and so the motion was filed on November 22nd. It was ordered on December 2nd, so I think it's pretty clear the court can take judicial notice of those because those are not disputed. In terms of the press release, Judge, again, I don't think it's something that's disputed. Mr. Hennessy brought it up several times in his opening arguments and motions or remarks on his motions that he's filed, so there's no dispute that this was filed or that press release is from the defense. And again, I think that court even says in their order for the gag order that on the court's motion in response to the defendant's undated press release. And so I think it is relevant because that it looks like the it looks like that prompted the court to issue a gag order without a hearing. And so I think it's important for the court to know that, again, I think the court's well aware of it. I think that's why the court made the order for the gag order. And so I think the court can take judicial notice of it. Hennessy says, may I? Sure. Thank you. The issue here, as he says, is contempt. So there would have to be evidence of a violation of a court order, which it cannot be. It just can't. It's the day before. Now, I understand, based on discussions in chambers, some people might be disconcerted by it, but it wasn't a violation of a court order, so it's not relevant to his allegations of contempt. The court says, I will show State's Exhibit 1 is admitted over objection as the objection goes to the weight that the court would give that particular exhibit rather than its admissibility. Is there anything else before we get into the actual evidence? It's so high and mighty. I just want to get to it. You're wasting my time, Mr. Hennessy. Mr. Hennessy says, are you taking judicial notice? The court says, yes, I'm taking judicial notice of the court's record dated December 2nd, 2022. Over the defense's objection? Yes, sir. Thank you. Judge, State's prepared to call its first witness. You may call your first witness. Finally. All right, so Judge, then the State would call Investigator Steve Mullins. Will you please state your name? Steve L. Mullin, no S. And where are you employed? At the Carroll County Prosecutor's Office as investigator. And how long have you been employed in that capacity? Since January of 2020. And prior to that employment, were you employed in a law enforcement capacity? Yes, I was. Can you tell me about that, please? I was a police officer with the DELPHI Police Department and then a deputy sheriff with the Carroll County Sheriff's Department, detective at the Carroll County Sheriff's Department, chief of police in DELPHI, and then at the Carroll County's Prosecutor's Office investigator. How long have you been a law enforcement officer, if you know? I figured last night 42 years. Okay, that's a long time. As part of your duties with the investigator, with being an investigator in the Carroll County Prosecutor's Office, are you working on the case of State of Indiana versus Richard Allen? Yes, I am. And tell me largely what your role has been in that case up to the state. It's been objection, relevancy. We're here for contempt. His investigation regarding the issues raised by the prosecutor's information is what is relevant. Overruled. Not his investigation of the overruled. Judge, I'll rephrase the question. I'm okay with staying away from that. So I want to move on. Mr. or Investigator Mullins, are you familiar with the individual by the name of Brandon Woodhouse? Yes, I am. And how are you familiar with him? Brandon Woodhouse has been arrested in Carroll County for various law offenses over the years. And is it fair to say he has a lengthy criminal history in Carroll County? Yes, he does. Now, Mr. Woodhouse came on your radar most recently in March of 2023, is that correct? Yes. How did he come on your radar during that time? I received a phone call from a person who identified himself as Dorina Hipsher. She informed me that there was a YouTube channel that Brandon had created. And did you go and view that YouTube channel? I did. And what did you see on the YouTube channel? On the YouTube channel, I observed that Brandon Woodhouse had a screenshot of the listed evidence in the Richard Allen case. And you were familiar with what the list of evidence was? Yes, I was. Have you reviewed the evidence or the discovery involved in the Richard Allen case? Yes, I have. And is it safe to say you're familiar with that evidence? Yes, I am. I'm going to show you what's been marked as State's Exhibit B, I believe. Mr. Hennessy says, State's Exhibit what? 2. I'm sorry, Judge, I misspoke. Exhibit 2. Investigator Mullin, so he said Mullins twice, now he says Mullin. Can you describe that document? Yes, it is the same as I saw on Brandon Woodhouse's YouTube page. It's titled Richard Allen Thumb Drive Map. And was that the title of the document that you saw on Brandon Woodhouse's YouTube page? Yes, it was. And tell me, you told me the title. What does that document contain? It contains information concerning the Richard Allen case, witnesses, and evidence for the case. And does that match what you saw on the YouTube channel for Brandon Woodhouse? Yes, it does. Judge, the state would move to admit what's been marked as State's Exhibit 2. No objection. All right. It's admitted. As your role of the investigator, you've also been tasked by me to assist in exchanging discovery with the defense for the Richard Allen case. Is that true? Yes. And tell me the normal procedure that you go through when you're exchanging discovery with the defense. My practice was to create an itemized list of the items that were going to be given over to the defense, whether they be information files or whatever they were, and then have the defense an agent sign for the release of those items. And so you would draft a receipt or a list of items that you were handing over to the defense, and then have that for defense to sign the over. Start that question again. And so you would draft a receipt or a list of items you were handing over to the defense, and then have that for defense to sign once those items were picked up. Is that correct? Yes. I'm going to show you what's been marked as State's Exhibit 3. Can you describe the document that I handed you? Yes, it's a receipt which I drafted for a release of evidence. I titled it 10 or 10 Allen. And can you outline the evidence? Is that a document that you drafted? Yes, it is. And does it have both Attorney Rosie and Attorney Baldwin's names on it? Yes, it does. And did this document describe evidence that you turned over to them as part of discovery? Yes, it was. And again, that's a document you drafted? Yes, it is. Judge, the state will move to admit what's been marked as State's Exhibit 3. Offered. Objection. It's never been provided to me in discovery regarding the contempt hearings. I asked to enlarge the discovery deadline. The court denied it, and I object because it's never been provided to me before, and it's not been connected to the thumb drive map, and therefore it's not relevant. Any response? Mr. McLeland says, yes, Judge, if the court would give us just a moment, I'm going to pull up the date of the email that I sent Mr. Hennessy that had that attachment in it. In terms of the relevancy, Judge, I believe it's relevant for information that's going to appear later on in the hearing in terms of a continued leak by defense of information. Judge, I apologize. I'm having trouble. I sent all the exhibits in the email, Judge, and I'm trying to get the court to a date for the email and confirm that Mr. Hennessy received it. Judge, I apologize. I can't seem to find an email at my fingertips here that I sent Mr. Hennessy, but it was included in an email with other attachments that I sent to Mr. Hennessy as part of the discovery for the contempt. Mr. Hennessy says, can I? No, he's looking. He's still looking. I guess I'm not sure what the objection is, that you didn't get it. Your client certainly got it, and they signed for it. Wow. Mr. Hennessy says, I didn't get it. What you ordered was to exchange the exhibits for the contempt hearing. Yes. Even if they had it, if they never identified it to me for potential use in the contempt hearing, that's the kind of notice that the discovery reciprocal discovery requires. And I would also note that the items that are listed in State's Exhibit 3 are not on State's Exhibit 2. And so 2 was admitted without objection because it was the attachment that was accidentally sent to Mr. Woodhouse. So since the items listed on 3 aren't on 2, it's not relevant. The court says, I'll show 3 is not admitted. Wow, she actually did something. Hennessy says, I'm sorry? She says, I will show 3 is not admitted. Thank you. I'm sorry, but the court says, do you need an assisted listening device? What a bitch. I'm sorry? Oh, no, I'll try to. Go ahead. McLeland says, thank you, Judge. And so, Mr. Mullin, or Investigator Mullins, what is it? Mullin or Mullins? Is your practice, again, to draft a receipt for the defense for when they picked up discovery? Sorry, I gotta move my heating pad now. I'm getting too hot. Okay, and you would list out the discovery in that receipt. You would list the discovery that you were turning over to them. Yes, I would. And then you would have somebody, a representative from their office or them themselves, sign for the discovery and date when they received that discovery. Is that correct? Yes, that's correct. And then, and that was your common practice for all items that you turned over as part of discovery, correct? Yes, it is, or was. Okay, do you recall, as part of discovery, that you handed over to defense, do you recall there being an interview with a professor from Purdue by the name of Jeffrey Turco? Yes. And what kind of was it an audio, video interview, or what kind of interview was it? I believe it was an audio video of Professor Turco that I handed over to the defense. And would you have gone through the same procedure when you handed over that evidence to the defense of making a receipt and documenting that in the receipt, meaning when I say that, meaning that discovery you're handing over to them? Yes, I would. And would you have that representative from their office date it when they picked it up? Yes. Do you recall from your memory that when the defense picked up the information concerning the interview with Professor Turco? I believe it was September the 27th. I don't have the document in front of me. Okay. And so you believe they picked that information up on September 27th of 2023. Yes, September 27th, 2023. I don't have any other questions, Judge. Mr. Hennessy, thank you. Cross-examination of Stephen Mullin. Questions by Mr. Hennessy. So you first learned about the Brandon Woodhouse YouTube from Ms. Hipsher? Yes, I was. What? You first learned? Yes, I was. Did you hear the question? All right. And there was another question he did that to earlier that didn't make sense. And what she told you was the Brandon Woodhouse actually had Rick Allen's thumb drive, didn't she? Something to that effect, yes. And that was not true? No. And on the YouTube, you saw the map of the thumb drive? Correct. And that simply identified what was on the thumb drive. Can you repeat the question, please? Sure. The map simply identified what was on that particular thumb drive. I'm sorry, I'm not sure if I understand what you're trying to say. Okay, I'll move on. Do you organize discovery for the prosecutor? Yes. Do you make a list that's handy for him and his assistants to locate any particular piece of discovery? I created an itemized list of the items that we have as I go along. Yes. So that would be like a map for them to go find the actual piece of evidence. I have done something like that, yes. And that is exactly what you saw on the YouTube. Only, the YouTube cracks me up. Only it was for the defense, correct? What I saw on the YouTube channel was what I said earlier, and the picture shows that it was, as the title at the top of the page, it said Richard Allen Thumb Drive Map. But it did not have any substance of anything of what anyone said, correct? It showed a list of items and witnesses. Correct. But it didn't say what the witnesses had said. Correct. So there was no substance to it. in that sense, yes. And then, did you see anything else on the YouTube? Mr. Woodhouse was simply talking about the items on the list of items that were on the thumb drive, or what he called the thumb drive. Did he show any pictures? No. And then, did you ever contact Mr. Woodhouse? I did not. Did you interview anybody else regarding the Woodhouse document other than Ms. Hipsher? No. Wait, no. Was that the answer? Other than Ms. Hipsher, no. That's the answer. Sorry. And you saw the actual email that was accidentally sent to the wrong recipient, Mr. Woodhouse? I don't believe I did. So you don't know what it was addressed to, Brad and not Brandon. I don't know. So, I don't know. Why did you not look at the actual email? I have enough to look at. I didn't have time to focus on any other issues other than this, and I handed my report over to the prosecutor. So you don't have time to do a job thoroughly and accurately so that you don't put innocent people behind bars or do stupid things like this or like the stupid contempt hearing. All right, so I have enough to look at. So you couldn't read a 4-line email, but you went through a multiple-page thumb drive map. I looked at what was on the YouTube channel and transmitted that to the prosecuting attorney. Right, but you just told me that you didn't have time to read a 4-line email that said Brad and not Brandon. You just didn't have time, right? I'm not sure if I understand your question. Okay. Well, I'm asking you if you have just said today under oath that you just didn't have time to review the 4-line email that was addressed to a Brad, not Brandon. Yes. Okay. So you, as you sit here, have no knowledge whether Mr. Baldwin intended to email Brandon Woodhouse, correct? As I said, I only looked at what I had in front of me. Right, so you have no information or knowledge that Mr. Baldwin intended to email Brandon Woodhouse. I don't know what his intent was. I'm sorry. The question is, do you have any information? Mr. McLeland interjects and says, I'm going to object. He's asked and answered the question. He can't speculate as to what Mr. Baldwin meant or did or not meant to do. Whatever Baldwin meant or did not mean to do. There we go. All right, so Mr. Hennessy says, well, then Mr. McLeland's not understanding the question either. I'm not asking him to opine as to what Mr. Baldwin's intent was. I'm asking him if he has any information or knowledge. He was assigned to investigate the Brandon Woodhouse. The court interjects, but that's not the question you asked him. You asked him what his intent was, and he said that was the objection, and I would sustain the objection. Okay, do you have any information or knowledge? Strike that. You were assigned by Mr. McLeland to investigate the Brandon Woodhouse information, correct? McLeland says, Judge, I'm going to object again. That's not what Mr. Mullins testified to. Mr. Mullins testified that he was contacted by Ms. Hipsher and that Brandon Woodhouse had a YouTube channel, and he viewed that YouTube channel. Sustained. After you spoke to Ms. Hipsher, did you have report that to Mr. McLeland? I'm sorry, can you repeat the question? Why is this guy such a putz? The person on the stand. Sure. After you got the information from Ms. Hipsher, did you report that to Mr. McLeland? Yes, I did. And what did he tell you to do? Document it. And why did he then go watch the YouTube? I'd already watched the YouTube when I reported it to Mr. McLeland. Okay, and then do you have any information from anyone that Mr. Baldwin meant to send an email to Brandon Woodhouse? Again, I'm going to object, Judge. It's information, Judge. Does he have any information? Overruled. That's a yes or a no. Overruled. Do you have any information that Mr. Baldwin intended to email Brandon Woodhouse. I don't know what that intent was. And Mr. Hennessy says, can you direct him to answer the specific question, Judge? Do you have any information? Oh, no, I do not. What? Why is this person so annoying on the stand? Mr. Mullins, whatever you are. So, do you have any knowledge of such? No. Thank you. And then and then you did no other investigation regarding Westerman's photos or any other leaks? No. If your employment was with PRO's Carroll County Prosecutor Office and you become aware of other leaks, other investigations of leaks? Mr. McLeland says, Judge, I'm going to object to relevance. That's not what we're here to discuss today, Judge. We, the state, has outlined the contemptuous information, and it's the state's belief that the investigation of other leaks and whether or not he's conducted those or looked into those isn't relevant to the information here today, Judge. Mr. Hennessy says, I just only asked if he investigated anything else, and his answer no would have been a lot shorter than this discourse. And of course she sustains it because she's her. The court says sustained. And then you remember giving a deposition on March 1st. Yep. Of 2023, 2024? Yes. And you were under oath? Yes. And do you recall saying that Mr. Woodhouse was displaying screenshots on his YouTube channel or video? Yes. So you did some screenshots of the YouTube video. I saw the display of his laptop showing what I've already described as an information contained in the Richard Allen thumb drive map. And then you took screenshots? I did. That's all I have. Wait. The court says, Mr. McLeland. Hennessy says, that's all I have. The court says, Mr. McLeland, Judge, thank you. Redirect examination of Stephen Mullin. Questions by Mr. McLeland. Investigator Mullin. The outline that you saw on Mr. Woodhouse's YouTube, is that something you created and then handed over to the defense as part of discovery? No. Okay, and so have you ever seen that document prior to viewing it on Mr. Woodhouse's YouTube channel? I had not. And so it's not something that someone else created that you turned over as part of discovery, is that correct? I did not create that document. Okay. When you saw the YouTube channel, the information in the probable cause, meaning the witnesses' names and what information sealed, or was information sealed? Do you know? I believe it was at the time. And so the outline listed several of the witnesses, including some juvenile witnesses. Is that correct? It did. Mr. McLeland, I don't have any other questions. Judge? Mr. Hennessy? Recross examination of Mr. Stephen Mullin by Hennessy. What was the date of the email? I don't know what the date was of the email. I never saw an email. So you don't know if it was before or after anything was sealed or unsealed. That would be correct. Okay. And then did you know that the affidavit with those names had been leaked by Gary Baudette before they were unsealed and before it was available to the defense? So the affidavits were leaked by Gary Baudette in the beginning? And who was in communication with Gary Baudette? Mr. McLeland. Oh, I think McLeland may have coordinated I already suspected it, but damn. I think McLeland coordinated those leaks with Gary Baudette or Fig Solves or whatever his name is. All right, and then it says, and before it was available to the defense. I don't know. Mr. Hennessy says, okay, nothing further. The court says, all right, thank you, sir. You may step down. Thank you. You may call your next witness. McLeland says, Judge, before I do that, this has been done. The court already has this document from Mr. Hennessy's, preliminary motions, but I think it's important to resubmit it again in this context since we're dealing with a contempt now. And so the state is going to ask the court to take judicial notice of what I'm going to mark as State's Exhibit 4, which is the email from the court. And it's the email chain that Mr. Hennessy has previously admitted. State's Exhibit 4 offered. The court says any objection. Hennessy says no. The court says all right without objection. 4 is admitted. McLeland says, and again, Judge, that shows there's an explanation there from the defense of when the email was sent, and so that clears up the date and when it was sent to give the court some context of when it was sent. Court says, okay. Mr. McLeland says the state would like to call Lieutenant Holman, Jerry Holman of the Unified Command, and we are going to get into that in part 2 because I gotta take breaks, guys. I guess I'm tongue-tied because they get so long and I have about me and my dogs have about a 1.5 to 2 hour sitting capacity, so I don't want to interrupt in between Holman's testimony here, so we will stop at this point. We still have a lot to go. This is part 1 that criminality, they broke it up into 2 parts, but I've only actually gone through about half of part 1, so it's probably going to be about 4 or 5 parts in total of this because it's a long doc and I can't do it all on my own without breaks. So anyways, thank you so much for watching and taking this ride along Delphi with me because it has been a crazy ride, that is for sure. So I thank you so much for watching. Please don't forget to hit that like on the way out. Make sure the notification bell is on so you don't miss future episodes or streams on this contemptuous hearing and other streams on Delphi and other topics that I'm doing which involve corruption and cover-ups and all the good stuff that is being hidden from us, from the government. So when it comes to true crime anyways. All right, so I'm not like a government conspiracy theorist, but so anyways, thank you again so much. Please check that notification bell and hit the like button, and I will see you in the next one. Take care, guys. Thanks for watching. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.